Navigating the difficult period after losing a spouse brings many complex questions, especially when it comes to financial matters. You might wonder how everything will be handled and if certain responsibilities now fall to you. It is a natural concern during such a sensitive time. The direct answer is generally no. You are usually not personally responsible for your deceased spouse's debts unless you were a cosigner, lived in a community property state, or the debt is directly tied to jointly owned assets. Each situation has unique factors, but this core principle offers an important starting point for understanding your obligations. The underlying reason for this depends on how debts are legally structured and state laws. Debts are typically individual obligations. This means that if only your spouse signed for a credit card, a personal loan, or medical bills, those debts belong solely to their estate. The estate, which includes all assets your spouse owned, is generally responsible for paying off their debts first before any remaining assets are distributed to heirs. However, if you co-signed a loan or a credit card, you legally agreed to be responsible for repayment, making you personally liable. In community property states, marital property and debts are generally considered jointly owned, which can affect your responsibility even if you were not a direct cosigner. To figure out your specific situation, the first step is to gather all financial documents, including loan agreements, credit card statements, and any outstanding bills. You should carefully review these to see who signed each document. If you find your signature as a cosigner on a loan, you will need to continue making payments. For any debts solely in your spouse's name, notify the creditors of their passing. The executor of the estate will then work to settle these debts using the estate's assets. It is also important to consult with an estate attorney, especially if you live in a community property state like Arizona, California, Idaho, Louisiana, Nevada, New Mexico, Texas, Washington, or Wisconsin. An often overlooked detail is that certain types of debts, such as mortgage loans and car loans, are secured debts. This means they are tied to a specific asset. If you wish to keep the home or car, you will likely need to assume responsibility for the payments, even if you were not on the original loan. If the payments are not made, the lender has the right to repossess the asset. This distinction between unsecured personal debts and secured debts tied to property you might want to keep is a key consideration. Understanding these nuances about consigned debts, community property laws, and secured versus unsecured loans empowers you to navigate this challenging period with greater clarity and confidence. By taking these proactive steps and seeking professional guidance, you can protect your financial well-being and honor your spouse's legacy without undue burden.